Good afternoon. I'm Praveen Fernandes, the Vice President at the Constitutional Accountability Center here in Washington, D.C., and I'm happy to be here with you this afternoon to talk about a big development that happened at the Supreme Court this morning. This morning, the Supreme Court issued its decision in Bostock v. Clayton County and related cases. I say related cases because the decision actually deals with three cases, not only Bostock v. Clayton County, but also Zarda v. Altitude Express and Harris Funeral Homes v. EEOC. And this decision was drafted by Justice Gorsuch, and the court held that an employer who discriminates against an individual based on their sexual orientation or transgender status violates Title VII's sex anti-discrimination provisions. Today's ruling is a massive victory for equality, but at least in terms of statutory interpretation, it's actually quite straightforward. The court basically read the text of Title VII in light of the original meaning of the statute's words, which seems like a pretty commonsensical way to approach things. As we argued in a brief that the Constitutional Accountability Center and Professor Katie Iyer submitted on behalf of statutory interpretation and equality law scholars, when an employer fires a woman because she's attracted to women, for instance, but not a man who is attracted to women, that action is necessarily because of sex. And that would be true even under the narrowest definition of sex that existed in 1964 when Title VII was enacted. And in the same way, when an employer fires a transgender woman for identifying and presenting as a woman, but the employer would not have fired her for identifying and presenting as a woman if she had been assigned the female sex at birth, that is discrimination that is based on sex and thus is prohibited by Title VII. So the court followed this logic in its opinion. As Justice Gorsuch wrote, an employer who discriminates against homosexual or transgender employees necessarily and intentionally applies sex-based rules. Another interesting part of the opinion explains that fidelity to the original meaning of the words of a statute is not the same thing as engaging in speculation about the drafter's intent. And this is something that's often confused. And so I was at least, happy to see the court clear this up. And here in Justice Gorsuch says, those who adopted the Civil Rights Act might not have anticipated their work would lead to this particular result. Likely, they weren't thinking about many of the act's consequences that have become apparent over the years, including its prohibition against discrimination on the basis of motherhood or its ban on sexual harassment of male employees. But the limits of the drafter's imagination supply no reason to ignore the law's demands. So again, it sort of clarifies that an analysis based on the public meaning of the text of a statute is not the same as sort of speculating about drafter's intent. So the quote basically goes on and says, when the express terms of a statute give us one answer and extra textual considerations suggest another, it's no contest. Only the written word is the law, and all persons are entitled to its benefit. So strong words. So I guess lastly, I would say it was a little bit, while CAC and its allies were obviously hugely happy to see this decision come down, it was a little disappointing to see Justices Alito and Kavanaugh engage in policy considerations in their dissents, given what they've expressed in their confirmation hearings and in their public statements about the modest role of a judge and what it means to be bound to the text of the law. I found this disappointing. So Justice Gorsuch seemed to call this out and seemed to call this approach out in the opinion and saying, if we were to apply the statute's plain language, they complain, and they meaning sort of dissenters and those who follow that logic, Any number of undesirable policy consequences would follow. Gone here is any pretense of statutory interpretation. All that's left is a suggestion that we should proceed without the law's guidance to do as we think best. But that's an invitation no court should ever take up. The place to make new legislation or address unwanted consequences of old legislation lies in Congress. When it comes to statutory interpretation, our role is limited to applying the law's demands as faithfully as we can in the cases that come before us. As judges, we possess no special expertise or authority to declare for ourselves what a self-governing people should consider just or wise. And the same judicial humility that requires us to refrain from adding to statutes requires us to refrain from diminishing them. So powerful words really about fidelity to the text of a statute, but also sort of the role of a justice and the role of a judge, presumably at the lower court level as well. So thanks. These are just some of the thoughts on this huge decision that came down today. Thank you for joining us. And I would encourage you, as I wrap this up, to go to our website, www.theusconstitution.org, for more information. You'll find both our release there, the brief that we submitted, again, with Professor Katie Iyer on behalf of equality law scholars and statutory interpretation scholars, and you'll find a variety of other materials there as well. Thanks for joining us.